to listen in.
The judge said it would be an absurdity. So, Your Honor, I hope the prosecution can take my word for it. If not so, I would request that we take an adjournment for a few minutes. If we say that we shall believe when we see, so that the court can satisfy itself that that order exists. But even from a casual look at the charge sheet, Your Honor, even without the order from the High Court, I believe with the experience of this court, the obvious consequence of an order staying proceedings against one party would be that the second accused person may not also be called upon to answer the charge sheet. Yes, and that is all right, Your Honor, and I'm appropriately guided. What the High Court said in these circumstances is that if the case against the second accused person proceeded...
Sorry, my Lord, but I mean, Your Honor, may I speak? Which High Court and where? He's not telling us which High Court, which judge and where, and with what. He's speaking for the judge.
I do not need to respond to that, Your Honor. That's where I started.
No. I didn't talk about a lot of time. I said an accused person has a right to be represented by an advocate or advocates of her choice. I said an accused person has a right to be represented by an advocate or advocates of the accused person's choice. And this advocate has a right by an advocate or advocates of the accused person's choice whichever number, and when they're in court, they have a right to address the court. And they have no time limits, which is a right. And I said in this case we had 44 lawyers, including one entity. And one entity with over 1,000 members. And all of them have a right to be heard. And the gist of my submission was that when we appear before our good senators, they should know that we have no control of the court processes and the length of time that they take. As much as we try to facilitate the expedition of cases, we have to succumb to due process. And if due process demands that 50, 40 advocates address the courts, that is what will happen. And that is why I made that submission.
Now, my question is, it is true that there used to have control and some of them are senators and other MPs. How many of those advocates address the court?
A few of them address the courts, and my submission is that all of them, if they wanted to, they have a right to address the courts. There were? There were 3 in this circumstance. Yes, my Lord. Yes, Your Honor. Yes, that is true. Correct.
Yes, so I'm not understanding to mean that.
No. I said in the normal circumstances, if they would have asked, and just to demonstrate how the criminal process works, if they would have requested to be heard, you would have to accord them opportunity to be heard.
Second accused, only one advocate spoke, and before you get to the stage, so that I could also know how many advocates from your head will support the issue of this high court on the table. So I don't know whether I'm trying to say that the court was according to time.
No, Your Honor. No. No.
If you had reached the point of the chance, definitely I would have put the question to you. How many? I put the question to you. How many from your side address the court? The only thing that the court will do is to limit the time that I will give. If I give the defense 20 minutes, let the defense 20 minutes, and also accord the prosecution 20 minutes. I think that one should be done.
Yes.
And the fact that one has so many advocates doesn't mean that all of them will be because this is not the only thing that the court is doing. The court is doing greater than others, and it has also been justice to both others. So I think on that understanding, it's clear that you not look at it like because you have so many advocates, you have so much that the court can always control that. So it's not true that you can use that is not the proper case of this person.
I'm properly guided.
I thought you were very organized. Can you answer? Well, there is a I wanted to make one ruling, which is applied after the comment. How much is
Kimuli. Yes.
If you say that I take your wife from the bank and you the amount of the court may not be delivered to misleading the court.
Yes.
If I take your wife from where you start,
Yes.
you should be able to give me that order in the next 5 minutes.
Well, I think in the next 30 minutes, it should be,
30 minutes will be ready.
it will be ready. I think the process of extraction. Yes, the judge has given the order. Malana, friend, senior counsel was there. Yes, we have the order.
So I do not want to, since this is one I don't think well, rather make invitation
Yes, Your Honor.
No, I just said maybe it was also, I don't know that, paragraph 5. Petitioner in ACC criminal case, but the petitioner is in the High Court. When we refer to the petitioner in the High Court in ACC criminal case here is a different person. Here she's not a petitioner.
My Lord, I think my learned colleague should read.
Read it.
My Lord, I think if I could assist the court and my learned colleague, read the order as a whole.
I will.
The petitioner
In ACC.
is the the petitioner in the petition before the High Court.
English words don't change. It is in paragraph 5. May I read?
Yeah, just.
I have to see it.
Criminal proceedings against the petitioner
Petitioner
in the High Court.
that an interim conservatory order be and is hereby granted saying criminal proceedings against petitioner in ACC criminal case. Petitioner is not in ACC criminal case. Petitioner is in the petition in the High Court.
Correct.
In ACC, the person is the accused person. Just that.
Okay, I need to stop you there. We'll come back to that vital point. As I'm being told, we need to cross over to the Mailimani Law Courts where the Chief Magistrate is back in court.
This court has now been properly and formally presented with the order of the High Court in petition number 2018, in which the Honorable Court has carefully examined and is now satisfied that the amended order has clearly and precisely granted the first accused hearing in terms of order number 5, a conservative order in respect of these proceedings in the following terms: that an interim conservative order be and is hereby granted staying criminal proceedings against the petitioner in ACC criminal case number 38 of 2018, pending before the Chief Magistrate Court at Nairobi until 9th of October 2018, when the court will give further directions on the hearing of the petition. In compliance with the said order, this Honorable Court gives the following directions: that these proceedings shall now rest at the point at which they are reached, that the status quo shall be maintained in respect of any orders the court had made so far, that 2 weeks following the date of the appearance of the parties before the High Court, there shall be a mention before this court for purposes of appraising or updating this court on any further directions of the High Court in respect of this criminal case that is pending before this court. So what we need to do in respect of this, because I can see the High Court says that the order is until 9th of October 2018, we need to take a mention date 2 weeks after this date so that you can come and brief the court on the further directions that the High Court will have made in connection with this case.
2 weeks after 9th of October.
It should be around 23rd or thereabouts. 23rd. Maybe you can push it up to around 30th of October so that the court can be kept updated.
Can we have the 22nd?
22nd?
Yes.
Is it okay, Mr. Mukherjee?
Yes, that's fine with us.
So we
The issue
have
does not arise.
mention on 22nd October 2018, and then the first accused, the second accused. Second accused can present the order of the court maybe next week.
Could we have a date next week probably for you?
On 12th.
On
Well, I will advise Mr. Kimule. Can you put it on Tuesday?
Tuesday next week.
Tuesday is when?
Tuesday, I think it's the 5th of September.
5th, eh?
No, 4th.
Then with your leave, allow me to place one important matter on record.
So sorry, it's okay. So mention in respect of the second accused on which date?
5th. 5th of September.
5th September.
5th.
So mention in respect of the second accused, he is present. Yes. Mention in respect of the second accused on the 5th of September 2018 for purposes of presenting the High Court order to the court or for any further order.
Most obliged. Yes, Your Honor, I was kindly requesting, with your leave,
Yes.
the DPP
Yes.
as instructed as to communicate this to the court, that the proceedings before this court though a matter of acute sensitivity and great moment, should not be taken as an attack on the independence of the judiciary.
Why are we having moments?
No, I think that makes them a bit uncomfortable. They quickly forget they raised the matter on when we were before you. Your Honor, that is stated without any reservations from our end. We respect the courts. We respect rights of individual persons. And as an office, we do expect that just like the accused persons do expect a fair trial, that whatever actions we take as an office should not, at any rate, be interpreted to mean that we are demeaning our judicial officers or the institution of the judiciary. Your Honor, purely, these proceedings have been brought against the two accused persons.
That is, so you are stating what?
Yes, it's an important.
If the order of the High Court did not come.
If the order of the High Court did not come?
That is what you have said.
Yes, we would have proceeded in the normal way.
Okay, please now make it short.
Yes, I'll make it very short.
As I've said, you know, these proceedings now are not supposed actually to be.
Yes, Your Honor, I am alive to that.
In fact, I think we are going against the order. In fact, I should not even be recording.
In fact, Your Honor, you see, I had said...
I respect, and that is why I gave you some brief moments to put out your concern, which I think is okay, because defense and that opportunity, but I don't think we should prolong it. I think you have made your point.
Thank you, Your Honor. I'm guided.
You have made your point.
I've made my point. I'm happy that Your Honor.
I've recorded the bit that you have indicated. I'm sure that's enough.
Thank you.
Yeah, I'm sure that's enough.
And they should be consistent. Because what Doc has said is very different from what Mr. Tete was saying. One is blaming the judiciary, one is saying we're not blaming them. Because she was saying the problems they are happening is because... So I leave it there.
Yeah,
actually, I wanted to address the court on the issues that Mr. Dura had raised.
Maybe you can
but
make
since
one comment.
The proceedings stand stayed, I cannot say any other words. I'm completely happy. Let's meet on the date of the mention. The High Court is different forum. Yeah. And come there to speak loudly, the same things you say now.
Very well. So I thank you. I thank you all for coming and for your presentations. I also thank you for being very kind to the court. You have expressed yourself with a lot of decorum. And for now, I say these proceedings now have come to an end. We shall meet another time.
I will thank you for your patience. Yeah.
Pictures coming to you live from the Milimani Law Courts, where the Chief Magistrate Lawrence Mugambi has actually granted stay of proceedings at his court, and to use his words in court, matter to rest and his status quo to be maintained on the criminal case before that court, which is the Anti-Corruption Court. And the Chief Magistrate says the High Court orders to temporarily halt any criminal proceedings against DCJ Philomena Mwilu